Live breaking news, Nez Nation. Our girl, Cash Money G, Fani Willis, who launched the case against Trump and 18 other co-defendants in the Georgia election interference case. Boy, she is having a rough go at it. Today, Ashley Merchant performed a master class in an open records lawsuit. I'm going to talk to you about that in just a second. But Fani Willis defied 2 subpoenas to show up in front of the Georgia Senate committee that is headed by Bill Cowsert. You know who that is. I love him. He has an amazing accent. I love his Southern drawl. And essentially, this is an oversight committee that is lawfully issued to have oversight over what's going on with the lower courts, what's happening in their district, what's happening in the state, especially related to the allocation of funds. And she defied those 2, and she actually appealed to have those subpoenas quashed, which they were denied. So guys, Fani Willis may be forced to compel to testify. That's right, because you never see her, right? I mean, where is she? She's not in the YSL RICO case. She never shows her face anywhere. I don't know. She only shows her face when she's having cocktails and conversations or hanging out with celebrities or doing speeches at church. Where is she? I mean, does she work? I don't even understand. What is all this taxpaying funding going towards? She's never around. So she may be forced to testify in front of that Senate committee, which will be live streamed, so you got to stay tuned for that. Now, today, a Fulton County Superior Court judge slammed Fani Willis's office for delaying an open records request filed back in January related to her historic indictment of Donald Trump. Quote, Judge Rachel Krause says, there seems to be a lot of delay here and a lot of effort, you see her on the screen right now, to keep pushing backward instead of making an effort to get to the substantive issue, which is, do these documents exist? She continued, if so, why have they not been produced? Or if these documents don't exist, then that's why they haven't been provided. This is very frustrating to the court, Krause said. You guys, these documents are at the center of an open records request filed by attorney Ashley Merchant, who represents Michael Roman, one of the 14 remaining co-defendants in Willis's indictment that accuses Trump and others of attempting to influence the outcome of Georgia's 2020 presidential election. I call it a sham. I've looked at it up and down, sideways and backwards. Which way you can, it is a total sham. Merchant is alleging Willis engaged in misconduct in her prosecution because her now admitted relationship with Nathan Wade, the prosecution's former special prosecutor. Merchant is also alleging Willis has violated the state's open records law, and Willis is disputing the charges. So I'm going to play for you a couple of snippets of this open records lawsuit, which it seems like, I mean, it was absolutely torturous to sit through. It was over 8 hours of court session today. And I've kind of distilled it, and really I'm going to share with you what I think are the highlights. I'm going to share with you, one, what is this open records request all about? Why is Ashley Merchant filing this? How does it relate? And then I'll show you a little bit of the really kind of almost, I would say, childlike, immature, combative at times. Even the judge had to say, stop and say, hey, you guys need to take a deep breath because this is getting nowhere, as it always is in Fulton County that's run by District Attorney Fani Willis. Fulton County is a hot mess. And so there was questioning with the chief deputy officer or chief operating officer of the District Attorney office in Fulton County, Mr. Dexter Q. Bond. And he was basically saying, I don't know what you're talking about, as usual. But let's hear first a quick clip of Ashley Merchant talking about why these open records are warranted, and it really shouldn't be a big deal at all.
Aware of that representation of what the defendant's position is and your response to it.
Well, that's no longer their position. So okay. They have told us that they are not the same. The 44 pages we were provided in the open records is not the same as the 197 that were provided 2 weeks ago in the lawsuit. They're not the same. So that representation was not accurate and I think needs to be corrected. We were not provided those attachments. They said that they were in the process of reviewing and comparing the documents provided by the DA and Fulton County IT. 9 months later, they're in the process of reviewing those. So it's clear these are not the same documents. And that's part of why we're here. That's part of the litigation and why it's relevant to question these witnesses, what this whole hearing is about. Who supplied the 44 pages, who decided what was in it, why the other documents weren't provided, and what else is outstanding? What else is there? Because this was a contract, a media monitoring contract, that was renewed by the county. It was so valuable it was renewed, and they want us to believe that there were 2 reports for a 2-year media monitoring contract, that they had 2 screenshots, and that is the extent of all records from $20,000 spent to a company to monitor Fani Willis's image.
Wow.
I think that we have a right to ask them that on the stand, if that is really all of the documents that exist and what steps they took to actually find those.
From a relevance perspective, what of the defendant's argument or the non-party witness's argument that these are, the need to question them is overburdensome or harassing?
It's not. These are public documents. These are documents that they are required to maintain. The law requires that they maintain these documents. So us asking them about these documents, it's very simple. These are documents that they have a public duty to maintain. The taxpayers paid for this. This wasn't something that was privately paid for. The taxpayers have a right to know what they're spending their money on. And this is just for critical mention. There's other classes of documents that we haven't even gotten to. But this is just for critical mention. These are open records. These are records that we're entitled to. I asked for them. I'm entitled to have them. There's nothing oppressive about asking them under oath, what did you do to find them? How do I know that I actually have all the documents? How do I know you didn't not give me something? Because we actually have proof that they didn't. We have a pattern already. Because they gave 44 pages, and they were cut and pasted, and then later on they gave us other documents. The documents they gave us on August 30th have some redactions in them. I still don't know what their redactions are. Why? I know what they are because they gave me the redacted information back when they gave me the 44 pages. I don't know why all of a sudden they decided to redact it. But we have a right to ask that. It's not oppressive. These are not difficult questions. It's not deep diving. They are public servants. This is a tax. The money, Fulton County paid for this service. We have a right to know what it is, and they have a duty to maintain it. So that's part of the issue. They have a duty to maintain this, and they have a duty to have these records, give us these records.
Where's the money, Fanny?
I mean, that's the whole point of the open records and open meetings requirement. To be able to peel the layers back and see what's going on. See where taxpayer money is going. If you've got a district attorney that's asking for extra funds, saying I can't process rape kits, I can't do all this other stuff because I don't have any money, we have a right to know where that money goes. It doesn't have to be related to any case. I can just be curious. I'm a taxpayer.
Right.
Where the defendants go mostly is that asking them questions at all when they've already said on a document, we don't have these records, I've looked and they don't exist, or I don't have them, that itself is the overly burdensome or harassing part.
Judge, I should be able to ask them if they've looked, because I don't believe they have looked. And I know my belief doesn't matter, but I've submitted documents that exist.
So what the judge just said there, this is insane. This is what Fani Willis and her team, I guess, or her, her district attorney's office, because she's never around, right? But this is what her and her team are essentially saying, is that Ashley Merchant is harassing them for asking for a very simple. She's representing her client with due diligence, with considerable aplomb, with an exemplary legal acumen. She's doing everything she can to protect her client and represent her client lawfully, justly, and accurately. And she has a right to know about these public records that have every bit of impact on her case and her client's innocence. And these guys, Fani Willis's office is claiming that this is harassment, that these subpoenas for open records are harassment. Can you believe this? Instead of giving it up. Here's the question that nobody's asking. What do you have to hide, Fani Willis? I thought you worked for the people, girl. What happened to that, Fani Willis? I thought you were all about your constituents. You're all about the people. You're all about transparency. So why are you afraid to testify in front of the Senate committee hearing? Why are you trying to quash the subpoenas? And why don't you just give up the records, which is your legal public service obligation to maintain and uphold? It doesn't make any sense. She's obviously hiding something. And remember, we had Ashley Merchant on our show. I love how she carries herself here.
in response that they have not provided. I've gotten them from other entities. So I have proof that they have not complied. So we have a right to ask them, how did you look? What did you do in response to this? And if I can go through, there's a couple, so let's talk about the confidentiality agreements. I asked for all of the confidentiality agreements that the district attorney's office required employees to sign. I requested that on January 9th in my open records. I followed that up on January 24th and said by letter, please don't make us sue you. I want the confidentiality agreements.
This is almost a year in the making, and Fani Willis will not give up simple, not very complicated things that is her absolute duty and obligation to divulge. I mean, when I keep saying, ladies and gentlemen, my fellow Americans, and she wants to go after Trump. Can you believe this? She wants to prosecute Trump. When I keep telling you, ladies and gentlemen, that DEI kills, that DEI is a cancer on this country, you are seeing Fani Willis, who is the personification of DEI's dangerous, damaging, absolutely unnecessary and anti-American, anti-meritocracy results and consequences right before your eyes.
One, I had Nathan Wade's. I had gotten it in another proceeding, and I had a business record certificate from Dexter Bond that it existed. Guess what his response was? No records exist. Well, so I've got a business record, which I've admitted, it's in the documents, a business record where he's certifying a confidentiality agreement from Nathan Wade, and then I've got the response in the open records that no responsive documents exist. So I should be able to ask him, why did you tell me no responsive documents exist when you were asked in a other case and you certified that they did? And now,
So did you hear that? So the guy that you're about to see right here, Dexter Bond, who is the deputy operations director, he told Ashley Merchant those records don't exist. I wonder who told Dexter that. Gee, let me think. I wonder who that could be. Is there any decision that goes through Fani Willis's district attorney's office that doesn't get the green light from the queen bee herself? I wonder. What do you guys think? Let me know in the comments down below.
2 days ago, I was given 22 additional confidentiality agreements. 10 months later, 22. I know more exist, but I was given 22. So
first they didn't exist, then he gives 22. She asked for 40. This is just unbelievable. And guess who's paying for all this? The poor, the real victims here, the tax-paying residents of Fulton County, who, again, cannot ever get their day in court because she's too busy chasing the limelight.
I can choose 22 employees in the DA's office who have signed confidentiality agreements. Jeff DeSantis, one of the witnesses we wanted to subpoena, gave a media statement that there had been confidentiality agreements signed in error and they were withdrawn. I followed up with that with another open records, making sure that they knew what I was talking about. You're giving the media a statement saying they exist, and then you're telling me in open records they don't.
Wow.
I have a right to question the witnesses about that. Why do I still not have those documents? I have 22 confidentiality agreements. I don't have them all. And I only got those 2 days ago.
You know, I have to say, before I show you this footage, I just want to show you a little bit of the contentiousness and the lack of cooperation from this witness who works for Fani Willis, of course. There's no way in a million years anybody could ever convince me, and you tell me, let me know if I'm wrong, that Ashley Merchant would be going through all of this in order to somehow rattle or quote-unquote harass Fani Willis and the district attorney's office. I think she has a lot better things to do with her time. I think that going through the rigmarole like this, going through these unnecessary hearings, I actually think is a waste of time on Ashley Merchant's behalf. The poor girl has to go through court to get things that seem very, very easy and are actually part of the public duty of Fani Willis and her district attorney's office. But let's listen in on a little bit. I can't wait to hear your thoughts on this. Let's listen into a little bit of testimony from the cross-examination of Ashley Merchant trying to ask Dexter Bond, what's going on with these records? Check this out.
Is that this particular request came in January 8th, right? We responded on January 9th. On January 18th, we responded to the documents, right? Once we responded to the documents, you accepted it. What I need you to hear is we closed that particular file. It was not elevated to me. Your second one was elevated to me. Let's call that critical mention 2, if I may. That critical mention 2 referenced the first critical mention, right? In that critical mention 2 that you just displayed to me, it had only one specific item. I am looking for analytical graphs. I responded to that request. So as it relates to anything that from the first time I gave it to you, it was responsive because this is me as the business record custodian. Once I received the second critical mention reference that referred to the first, you and I can agree that the first had, let's just say, 5 things. You only made mention of one thing in the second one. I assumed 1, 2, 3,
very
4
contentious
was resolved,
and angry.
that is closed. And
Why are
I
you yelling?
responded on January 26th to the remaining issue. So as it relates to compilation, I want to be very clear.
He's making a
It was sent to you. It was responsive to your request. I moved on. You referenced it. Once you referenced it, it was elevated to me. The elevation was one specific item. So I assumed that the first matter was resolved. And the only outstanding issue related was analytical drafts embedded into something, which I responded to you on January 26th. Is that clear?
No.
Okay.
And so let me break it up because it was a lot. So I tried to take notes. First, you said I accepted it. So on January, whatever the date was, 18th,
He seems really
I accepted it. When you said I accepted it, you sent me a document and I accessed it, and it was immediately closed. So you're saying that's an acceptance of the open records response?
I am saying that we sent you the open records response that's responsive to your request.
Yes.
All right. I am also saying that you opened up another open records request. In your second open records request, that's why it's very important we do not refer to this as globally. You make reference to the first.
Yes.
You said here in court that the first one was very detailed, in which I agree. Okay? I let you know that I did not have anything to do with that. You gave responsive records. Once you respond to me in reference to the first one, and there's one thing outside, I am a reasonable person, that's the word that you use, will assume that the first is over. It's done. It's complete. So I am assuming, reasonable or not, that you accepted the open records request because you said, here's the second one, I did this, I'm referencing that, and here's a small section.
So you assumed I accepted it, and
it was delivered.
Hold on.
Is that better?
Delivered.
It was sent to you on January 18th.
Yes.
No, there is no reason to argue about the semantics of what we're talking about.
So essentially, that's kind of how it went. Like, it kind of went like that back and forth time and time and time again. And it went on and on and on for 4 or 5 hours. It's very simple. You have an obligation and duty as a public servant to the tax-paying residents of Fulton County to keep, maintain, and supply these types of documents that are known as open records, public records. Just give them up. Don't tell me they don't exist and then tell somebody else they do and then give only a couple here. And then you can't pick and choose. And so poor Ashley Merchant, these defendants. Remember what the pit bull said, the goat. Prosecutors are not only supposed to definitely not appear to be, definitely not have any impropriety, but they're supposed to be held to a higher standard. The appearance, even the appearance of impropriety is supposed to be avoided at all costs. 6-7 hours of this back and forth. Nothing got resolved. They're going to go again tomorrow and testify. If there's anything that I need to keep you up to date with, your boy Nez has you covered. But I can't wait to hear your thoughts on this. Fani Willis and her whole entire case is falling apart. There's absolutely zero debate over that. I'd be shocked, especially if Trump wins, which he should, knock on wood. I would doubt that she doesn't dismiss all these charges, because the whole point of this and bringing it to trial, the expeditiousness of taking this indictment towards the former president was in the hopes of stopping him from running, stopping his popularity. Everything's backfired. All the lawfare's backfired. Cash Money G looks awful. She looks atrocious. Her credibility is in the toilet. So I wouldn't imagine, but it's just falling apart over and over again. But I'm going to keep you up to date. You know your boy Nez has you covered. Let me know in the comments down below as always. I can't wait to read your comments about this. Check out these videos coming up on the screen right here. Follow, subscribe, sign up for our free newsletter in the pinned comment, show notes, and description. And as always, may God bless you and may God bless America. I'll see you soon.